We're going to begin this evening with a correction. And you know, I feel fairly foolish. I should feel foolish. I made a typo, a serious typo 2 weeks ago, and I need to correct that. So I'm going to begin that way, I guess, if I have this thing on, or I'd like it to be on. I wish it was on, and we'll pretend that it's on, and there it's on. All right, here we go. The Constitution was drafted in 1787. I had 1887. I feel pretty foolish about that. I don't know what 100 years among friends is, but it is something. Doug Lane brought that to my attention afterwards. I think Doug may have been there at the time, so he would be particularly qualified to bring that to my attention. But so I need to make this correction. So the Constitution was drafted in 1787, not 1887, is ultimately ratified in 1788. All right. So let's go to the verses that give us the basis to have these kinds of discussions. Of course, we are subject to to higher powers. Every soul, that certainly includes us. The Romans, the Christians in Rome, to the first generation that got this letter, it applied to them. It certainly applies to us. And of course, this also from 1 Peter, referencing the fact that we should be subject to the ordinances as they come from the Lord, as ordinance of man for the sake of the Lord. I've added a verse this week because there's something that happened this week that came to my attention, may come to yours as well. We certainly are subject to the powers that be. We're believers. We live in this country. We're subject to the powers that be. But at the same time, there could certainly be a circumstance under which we would want to hold on to this verse and pay particular attention to it. There could be a time when it's necessary to obey God rather than men. And I would presumably we'd be prepared to do that. What brought this to my attention was, and I directed the preacher to this, and he said, I think it's probably appropriate to do this. There was an article you may have read this past week in the paper about a law that was passed in Canada. Now, I recognize that we're not subject to Canadian laws, but let's agree that we have many Canadians that spend time with us, and some of us presumably get to Canada periodically. But not only that, they're not altogether dissimilar from us. In other words, this happened in Canada. It makes it even more believable, or likely, I guess, that we could see something like that happening here. Here's what happened. I'm going to read to you. This will be in the notes that are available at the end of the session tonight. The controversial legislation, which went into effect on January the 8th, that's 2 weeks ago tomorrow, after being fast-tracked through the Canadian Parliament in December without extensive debate, describes as a myth the belief that heterosexuality, that is, that men are attracted to women and women are attracted to men, and cisgender, that means that people identify with the gender with which they were born. I was born a male. Generally, I think that makes me a male. That's called cisgender. So it's a myth, the belief that heterosexuality and cisgender identities are preferable. And counseling that does not align with such a worldview now carries a potential 5-year jail sentence. So the fact of the matter is this was apparently designed to keep those people who wanted to deprogram people who expressed views relative to homosexuality or whatever, or the fact that they wish to be a gender differently than one they were born with. But there's nothing in there which suggests that a pastor, for example, might also be impacted by that. And I just have to tell you something. I have no idea how this is going to be enforced. It's really not about this happening, except that it did. And I can tell you that there are people who, if they could, would do exactly the same thing here. So I'm going to tell you something. We need this verse as well. We're subject to the authorities, but understand this. There could be an occasion when we need to obey God rather than men. And we would pray that we would have the courage to do that very thing. All right. I'm going to invest just a few minutes here, and I mean very few minutes, and review some of the thoughts from last week. We 2 weeks ago, it's been 2 weeks, and I just want to be sure I'm going to invest just a few minutes, run through some of those slides just to kind of reinforce in our minds where we were. So the Constitution is the supreme authority. That's it. The Constitution is. Not the Declaration of Independence, not anything else. The Constitution is, and the Supreme Court decides what the Constitution says. So that's why the Supreme Court is important as it is. And I didn't probably draw a lot of attention to this asterisk at the bottom last time, but I may have not given that quite enough. You know, there could be an occasion when we hear that there's a law that's been passed, for example, and we think, no, that doesn't sound right. I don't see how that could possibly be. Well, understand this. Unless it's challenged in the courts, whatever the law is, that's the law. What the ordinance is, that's the ordinance. All of those are presumed to be constitutional unless and until they're challenged, and that's why these issues coming up in the courts become so important, because in fact in that situation they are challenged. So we talked a lot about the first phrase of the First Amendment, which of course we refer to as the freedom of religion portion of the First Amendment. The first phrase contains two clauses. We talked about that. The No Establishment Clause and the Free Exercise Clause, those two. The No Establishment Clause has particular things that have been addressed. We talked about that. As far as I know, this is the only place in the Constitution where there's no exceptions, none. To my knowledge, there's historically been no exceptions to the No Establishment Clause. Specifically, the case, and we talked about it, Everson versus Board of Education. This is what the Supreme Court said this means, and that's why that's the law. No official government church. There never has been an official government church in our country since its foundation. Even though, of course, some folks might suppose there had been or wish there had been, it really hasn't. No coercion by the government. The government can't get after you to go to church or get after you to stay away from church. There's no coercion by the government, period. No punishment by government for beliefs. That's specific. You can believe whatever you choose to believe, or you can believe nothing, and there'll be no government interference or no punishment by the government. No government preferences. No government which no indication that the government prefers one religion over another, or no religion at all. And of course, no government participation. The government can't participate in religious activities. Religious activities cannot be part of a government entity. So that's no establishment. Then, of course, we come across the second one, which is talking about the free exercise. And there are exceptions to the free exercise. There are times when the government has interfered with the free exercise of religion. No exception to the first, or to the second. Okay, this can really get deep, and I promise you I don't want to wade into this too much, but there's this particular reason why I introduced this 2 weeks ago, and I wanted to come back and revisit it slightly tonight, because Roe V Wade. We're going to park upside that bad boy tonight and be on that like odor on a hillbilly. The Roe V Wade specifically uses this language, strict scrutiny language, that is compelling state needs and narrowly tailored solutions. So that is particular addressed in Roe v. Wade, and so that's one reason why the levels of scrutiny are important. So here we go. If the law challenges is specifically designed, in other words, if there's a law that comes after a particular practice of religion, there's something that religion is doing that the law wishes, some ordinance, some state statute, someone says, no, we shouldn't be doing that, then that gets what's called strict scrutiny. It must be a compelling state interest. The state needs this, which is important, and there's no other way to get it. Narrowly tailored means. That's strict scrutiny. That's the language of Roe. That's the language of Roe. Almost never survives a review of the Supreme Court. When it gets strict scrutiny, it almost never survives. I mean, there have been efforts at restricting religious practices, and if it's specifically designed to interfere with the religious practice, that almost never survives. The example I used was Church of Babaluai, and these are people who wanted to sacrifice animals in the city of Hialeah, Florida. Said, no, we don't want you sacrificing animals. It did not survive. So there we go. If the government interference is unintentional, then it gets less. In other words, it didn't come after the church specifically. I gave you as an example, if some state or the federal government decided to tax all 501c3 organizations, every charitable organization is going to pay taxes, and churches would be among those and get taxed, then it's unintentional, at least in theory. The intermediate scrutiny says there's an important state interest. Doesn't have to be compelling, it's got to be important. And an argument can be made that taxes are important. I mean, I'm sorry, that's how government functions. And that it must be substantially related. And so I just have to tell you, if there was a political will, and there are those who would tax 501c3, including churches, I think that would survive constitutional muster under the intermediate scrutiny. I believe that. Now, we're not there because I don't think the political will is there for that. The activity the government seeks to regulate is criminal, then I'm sorry, then the church is in trouble. We use the example of polygamy. That's against the law. So the fact that some group believes that polygamy is appropriate, it's against the law. And so there can be laws against that. Whether they're enforced or not, that's not my point. The point of the matter is those will survive scrutiny because it's a criminal activity. All right. There were some points that we didn't get to last week, and but they were in the notes that were distributed, and I'm going to take just a few moments, a very few moments, and hit a couple of these points because I think we should. So these are additional points. It doesn't matter if, all right, when the court's determining whether or not something is restrictive or overly restrictive involving religion, it doesn't matter if the religion is organized or unorganized. It should be good news for Baptists, right? I mean, you can't talk about less organized people than Baptists. But in seriousness, if we decided right here, right now, we're going to start our own religion, the Church of Enlightened Titusvillians. If we decided that, we would have as much protection under the Constitution as the Baptists, or the Presbyterians, or the Episcopalians, or the Catholics, or anybody else. We'd have just as much protection. It doesn't matter if it's organized or not. And this is the one that might be a little hard to get a hold of, but it's true. It doesn't matter if even only one person holds the view. If even only one person holds the view, it doesn't matter. They're still protected under the present interpretation of the free exercise clause. They still can practice their religion. There's an example that's given, and again, it was in the notes from last week. We didn't get to it, but Thomas versus Review Board. What happened was this guy named Thomas was a Jehovah's Witness. He was a JW, and he didn't want to work at a munitions factory. So he said, I don't believe that, my conscience doesn't want me to work in a munitions factory. I don't want to work in a munitions factory. And so he was denied an employment compensation because other Jehovah's Witnesses did work there. So what the review board said, whoa, if you're a JW, then you can't, I'm sorry, you can't use that as an excuse because other JWs work at munitions factories, so you can't draw unemployment using that as an excuse. And the Supreme Court said, no. If he's the only one who has a conscientious problem with working in a munitions factory, only Jehovah's Witness on the planet, he's still entitled to unemployment compensation because he firmly holds that belief. Now that's really where my notes stopped last week, but of course as I was looking at this a little bit, what happens is almost inevitably someone comes up with, well, what if somebody makes it up? What if somebody pretends? What if somebody says, whoa, I really shouldn't have to do that. I should still be entitled to whatever benefit that I might have gotten. I shouldn't have to be restricted because you know what, I really don't think I should work in a munitions factory, as an example. So I asked this question. What if someone falsely claims a firmly held religious belief? You can all picture something like this happening, I hope. You can. I think you can probably all visualize somebody saying, I have a particular belief because it's to their benefit, when maybe they do it, maybe they don't. Well, thank you for asking the question. Here's the answer. The law is the law. The law is Thomas. The Supreme Court said if only one person has this view, they're still entitled to protection. That's the law. But whether or not Thomas actually believed that, that's a factual issue. That's an issue of fact. Whether he actually believes that or not would be determined by the trier of fact. In a trial court, that's the jury. The judge reads the jury instructions. That's the law. But the jury decides whether or not the defendant, in fact, is guilty under the law. So it's a factual issue. So here's what would happen. Whether the claim was found to be under the law is a factual issue and would be determined by the weight of evidence tending to prove sincerity. So here's what would happen in that situation. Somebody has to attest the fact this guy really does believe this way. He's talked about this for years. Every time something like this comes up, this guy, he says, I just can't imagine, building something that blows people or whatever, turns my microphone on. He can't imagine people ever being whatever. That's a factual issue. Now, I'm not going to take much time with this, but I think this is an interesting exercise. And you know what? I got the mic. So you may have never been given this little mental exercise or not, but I remember at different times people saying to me, if you were on trial for being a Christian, would there be enough evidence to convict you? Now this is different, but is similar. If you ever were in a position it was to your advantage to assert some religious view, would there be enough evidence to support you holding that view? Whatever it is. There clearly was in this case. Thomas this worked for Thomas. But I got to tell you something. He makes this up, and there's no evidence he actually believes that. He gets no unemployment benefits. End of discussion. And that's probably the way it should be. All right. We spent enough time with that, but I'm sorry. I think these things are interesting. Whether they are or not, who cares? All right. So, Roe v. Wade. One of the early things when discussing this in advance in this little video promo we did, we talked about we're going to get to here. And I just have to tell you something, we're all over this evening. In part because, of course, the timing of it, but I mean, this is our subject. We're going here. Now, you probably knew this, and I apologize to anyone who finds this to be not productive, this discussion, because of things that you may have already known. But just on the outside chance, and I want to be 100% sure we're on exactly the same page, prior to Roe, prior to this decision, all issues relating to abortion were decided by the states. And please understand this. If in June, or whenever the court comes back, if they reverse Roe, that does not mean abortion is legal. It means it's up to the individual states. It goes right back to the individual states. It does. To the 50 states. And that's based on the 10th Amendment. Now, I don't want to spend a lot of time with the 10th Amendment, but each one of these things that you kind of pick it up, it's like you're picking up this tail and you kind of want to follow at least a little ways. Because this, you have heard, or you will hear even more about this, the 10th Amendment, and the fact that these things devolve to the states. Responsibilities goes to the states. There are some people in this country who, of course, would prefer that the federal government, that Congress, made every decision. But that's not the way our government was set up. We have a republic, a constitutional republic, and it's made up of 50 states. And the 10th Amendment is where we get this. This is where this is locked in. Briefly, that's the 10th Amendment. Powers not delegated. It's 28 words. And I have to tell you, it's a little convoluted. They did not waste words, the people who drafted this. Powers not delegated to the United States by the Constitution or prohibited by the states, reserved to the states respectively or to the people. Briefly, very briefly, here's what it says. Does the Constitution reserve an activity exclusively for the federal government? Is there something in the Constitution that says this is the federal government's purview and not the states? And the answer is there's a few times. Yes, there are. The common defense, we don't raise armies. The individual states don't raise armies. They have militias, different. There's a few places, and disputes between states. If there's a dispute between Georgia and Florida, that's under the federal purview, not under a group of other states. That's reserved for the federal government. The second thing that the 10th Amendment says, does the Constitution forbid an activity be conducted by the states? Is there anything that's reserved specifically for the government or forbidden the states? That's what the 10th Amendment says. And there's a few. Can't make foreign treaties. We don't make treaties with Mexico or Guatemala or Russia or anybody else. Florida doesn't do that, so we don't make foreign treaties. And we can't create new states. No, we can't say the Panhandle is going to be its own state. Some people might, but we can't. It's going to be its own state, get two more senators. You can't do that. No. So there's some things that are reserved, that are reserved for the federal government, not many, and some things that are forbidden by the states, not many. Everything else belongs to the states or to the people. That's the 10th Amendment, and that's why abortion will, again, the issue of abortion will go back to the states, because it's not specifically given to be a federal issue. All right. I'm going to take a breath, and then I'm going on. There you go, Becky. I'm sorry. You didn't think I needed to breathe, but I do. I need to take a breath. Oh, there you have it. I'm in. All right, here we go. Roe v. Wade. All right. Now, one more time. Maybe there's no confusion here. But I will tell you, if you read very much, you see there's an enormous amount of confusion exactly what this case said, what it says. And I'll tell you, we're going to fix that. First of all, it was a Texas case, and Texas had a law that said life begins at conception, and therefore total ban on abortion. That's justified, because when there's an abortion, then we've taken a life. That's what the state of Texas said. And of course, that was challenged in the courts. And the Supreme Court said the following: there's no indication in the Constitution's definition of a person that includes a fetus. That's what the Supreme Court said in Roe. There's nothing in the Constitution that says that a fetus is a person. None. It's not there. Can I tell you something? It's not. It's not. So the Supreme Court said there's no indication the Constitution's definition includes a fetus. And here's what it said: there's no consensus as to when life begins among experts in medicine, philosophy, and religion. This would be in the notes that are handed. We need not resolve, this is a quote from the Supreme Court in Roe, we need not resolve the difficult question of when life begins. When those trained in the respective disciplines of medicine, philosophy, and theology are unable to arrive at any consensus, the judiciary, in this point in the development of man's knowledge, is not in a position to speculate as to the answer. So they said, there's nothing in the Constitution that says a fetus is a person, and there's no consensus about when they become a person. That's what they said. So they're not, the Supreme Court's not prepared to say. That's what it said. So what did they do? Here's what Roe v. Wade says. What they said was, we want to balance, on one hand, a woman's right to privacy. A woman's right to privacy. And on the other hand, the state has a genuine interest in being sure that, certain medical procedures are licensed or whatever, and there is interest in prenatal life. So on the one hand, a woman's right to privacy. Now, some of the people that believe, that are pro-life, that believe the way I presume everybody here does, have criticized this notion about this right to privacy. And so that's where the word penumbra comes in. The Supreme Court used that term to describe, it's kind of like a zone. It's kind of like this aura that surrounds a woman, in this case, because we're talking about abortion, which is a zone of privacy. It's kind of like there's a shadow, it's attached. If you have this person, then you just naturally have privacy. And there's been a right to privacy. And there's been criticism that there's no right to privacy in the Constitution, and there's not. And there's not. So a lot of people have criticized this notion that surrounding a woman, there should be a right to privacy. I would be careful with that criticism, because it seems to me like I don't want there to be an opportunity for the government to interfere in all sorts of kinds of things. I think there is a right to privacy that is certainly implicit in the Constitution. It seems to me like there is. In any event, the Supreme Court said there was. If you disagree, bless you. But here, so on this hand, there's a right to privacy, and on this other hand, there's this. There's the notion that the state has an interest, kind of like now. I mean, doctors are licensed. You do that, and if you want to go to a physician, you want to get a prescription. So there's an interest in the state in providing medical care. So that's on one side, plus prenatal life. Here's what they said. That's the balance. They're balancing. That's what Roe's about, balancing those two interests. In the first trimester, no restrictions on abortion except for medical safeguards. In other words, during the first trimester, the state can say that a woman could get an abortion only through a licensed medical provider. That's it. They can only for a medical safeguard. That's the only restriction whatsoever. There is no consideration given under Roe on prenatal life. None. Zero. No weight put on that whatsoever under Roe. In the second semester, there can be some restrictions that are narrowly tailored to the mother's health. Again, no consideration given to the unborn fetus, to the life of the unborn. None. But you could have some additional restrictions during the second trimester, and there are some things that the state can do. Licensed clinics, for example, not only just physicians, but there's a variety of things that are possible, but they must be narrowly tailored to the mother's health. If it doesn't speak to the mother's health, no additional restrictions on abortion in the second trimester under Roe. In the third trimester, any restriction, except for the mother's life or health. So in the third trimester, this is generally when considered, when the prenatal life is, preborn life is considered to be viable. And at the time it was given about 26 weeks. I'm sorry, you can agree or disagree. I'm just telling you what it says. That at the time it was about 26 weeks, and so they said after 26 weeks, now we're giving some weight to the preborn. We're giving some weight to the preborn. And you can have any restriction on abortion you want in the final trimester, except for the mother's life or health. Now, I want to split those two, because it's not a small thing. It's not a small thing. When you say an exception for life or health, it's not a small thing. Exception for life. You can visualize at 30 weeks, something happens, and somebody has to make a decision. Only one can survive. Only one. Only the mother is going to survive with the child. You can picture circumstances under which that might happen. What this says, you can't restrict abortion. I mean, abortion, can be restricted, any restriction after 26 weeks, except for the mother's life. So what they're saying is, no, you're not forcing the mother them to say, we're going to let the baby live and the mother die. You're not. We're not. The state's not going to be allowed to do that. You cannot force the mother to give up her own life for the child. She may choose to, but you can't force her to. That's the mother's life. But health, that's the one. That's the one. When it includes, and some people have interpreted it to say mental health. It's just a stressful thing to me to have a child right now because the father has gone or whatever, so I should be able to abort because of my mental health. Because of my mental health. That is a huge gaping hole in any restrictions on abortion. If the healthcare provider says, well, it's for her mental health, then there can't be any law which against abortion. There can't be. So this is Roe, and understand this. Anyone who explains it differently, I'm sorry, that's Roe. That's Roe. That's Roe. It's also not the law. Roe has been overturned. Yeah, it has. In part. And I'm going to tell you, we'll go exactly there. But one of the questions that has come up often on this is, and one of the things that people talk about this when it comes, this is settled law. The people who like this law, this interpretation, this case, they say it's well settled. It's the law. The term used is a term which you'll see or you have seen is stare decisis. The decision stands. It's also known as precedent. So since Roe v. Wade has been settled, it's settled law. Come on, sucker's 49 years old now plus a day, isn't it? So this argument is that's settled. We shouldn't go back and revisit it. And, the fact of the matter is, this is not an unimportant point. It's not an unimportant point. If every time a new person was appointed to the court, or every time the court changed, went back and revisited all of the cases prior to that time, nothing would get done. So there is great weight given to precedent. I'm sorry, and we can agree or disagree, but it's probably a good idea that if something is settled, it's settled. It's settled. Except when it's not. Except when it's not. The fact of the matter is they overturned less than 2% of the previous holdings. I already mentioned it, that Roe v. Wade has been overturned in part. I'll tell you exactly where it was, what's different about that, but less than 2%. And that's probably what you would expect. I mean, if you didn't have this, nothing would ever get done. So if it's settled, it's settled. But there are some cases, notable examples. Most of them are in the area of criminal law, where the court has totally overturned, upside down, all previous holdings of any kind. There's a case, Mapp versus Ohio, which talks about the exclusionary rule. If evidence has been taken without a warrant, it can't be used against the person taking it. That was a big deal. Gideon versus Wainwright says that everybody's entitled to a counsel, the public defender, even if it's a misdemeanor, if they could go to jail. And of course, Miranda versus Arizona, everybody knows what Miranda says. So there have been times when in criminal law when there has been precedents overturned. But probably the most famous one overturned is this one, Plessy versus Ferguson. Plessy versus Ferguson was an, well, you can see it, can't you? It's an 1896 case. And what happened was, I believe it was 1887. I don't know. It sure wasn't 1787, but it was. There was a law passed which said that African Americans had their own railroad cars. They couldn't ride with white people. Well, hello. The first state to make that law. Are you ready for this? You're not ready for this. Florida. Florida was first. Then Mississippi, Texas, I forget the third one. That followed very quickly. But whatever the case, there were these laws that said that African Americans couldn't ride in railroad cars with white people. And Plessy versus Ferguson said, we're good with that. We're good with that. I have some of the language in my handout, but basically what they said was the fact that there's a legal distinction between races, that doesn't mean that one's treated better than another. As a matter of fact, this is where this separate but equal came in. You remember hearing about this. Some of us remember that during our lifetime, separate but equal. So Plessy versus Ferguson, and that was well settled. It was well settled until Brown versus Board of Education. In this case, well, you see when it was, and some of you remember it, or not. But this case was argued, Thurgood Marshall, the first African-American Supreme Court justice, argued on the side of Brown. This was Board of Education, I think, Topeka, Kansas. Whatever the case, are you ready for this? 9-0. 9-0. The Supreme Court said, no. That's not good enough. Separate but equal doesn't work at all. And 9-0. They said they overturned Plessy versus Ferguson. So the fact of the matter is, some well settled laws, some that's rock solid, is overturned. And the occasion may come when that happens here. But stare decisis, if you haven't heard it, or you haven't talked about precedent, or you haven't talked about well-settled law, then you haven't really been paying attention, because that's what a lot of the reason why people say Roe v. Wade should not be overturned, because it's well settled. Of course it is. So this case, in fact, is the most recent on this subject. You may hear some about it. Maybe you've already heard about it. Maybe you read something about it. But there's some things in Planned Parenthood versus Casey that changed, that overturned parts of Roe v. Wade. The first thing it did was it upheld the right to abortion, that holding in Roe. So the first thing it said was, we're with Roe on the right to abortion. That's the first thing that Planned Parenthood said. But then they said, they overturned the trimester in favor of viability analysis. Now, this may seem like a small thing, but the fact of the matter is, it seems to me like, and it's not crystal clear from reading the case, I have excerpts of it in your notes, but it's not crystal clear to me, but this may have been a nod to people who, and recognized the fact that while the Supreme Court was not prepared in 73 to say when life begins, it was generally said viability began at around 26 weeks, and of course, by 92 it had moved backwards. In other words, viability, people, premature babies were surviving at an earlier rate. Whatever the case, viability probably reduced the 26 weeks back a little bit. There are some states, including this one, that has outlawed abortion after 24 weeks, except under certain circumstances. So it overturned the trimester analysis. It all goes back to viability. And the second thing it did was it replaced strict scrutiny, the standard of review in Roe v. Wade, in favor of an undue burden standard. And you know, again, it's a little complex. And I don't make a living anymore making things complicated. But here's really what it says. If the purpose of the statute is obviously, the purpose of the law against abortion is obviously to make it more difficult for women to get an abortion, it's to make it harder. So they got to travel, They got to wait some period of time, maybe after a ultrasound or something. If the purpose of the statute, the purpose of the law is to make it more difficult to get it, it's automatically suspect. It's automatically suspect. That's the undue and different. First time this undue burden standard has been used in a situation quite like this. It's used more like in contracts or something like that. It's not brand new, but it's the first time it's used in this particular context. But the fact of the matter is, Roe is not the last word on abortion. Planned Parenthood versus Casey is. But if Roe is overturned, then Casey, the basis for Casey has also been overturned. So Roe is still, of course, getting the most attention, and for that reason. Now, I recognize a couple things. Number one, I'm capable of speaking quickly. No, really, I am. I've read somewhere that people understand, people speak typically 160 words a minute or 180 or whatever, but people can understand more quickly if they concentrate. I usually start at around 450, it gusts up to 600. So I'm okay to break for a moment and answer any questions about Roe that I can. Because I really think it's important for us to understand, if we're going to have a conversation about something, if we're going to purport to have a position, I think it's important to know, to understand. So if you got a question about Roe, I'm happy to go there. Dobbs versus Jackson's Women's Health Organization is the case that's in front of the Supreme Court right now. And I'm going to explain that in a few moments. But before I go there, if somebody has a question about Roe, or something else, ask me something else, and you know what? We'll either answer it or we won't. Yes, ma'am. Hold it. The preacher's on his way, Carolyn.
I want to know how they get away now with the abortion whenever it's way past the 4 months, even later.
Okay.
How is that? How are they?
Okay. How do you get by with that? First of all, Roe does not say that it is against the law after 26 weeks. Doesn't say that at all. So in an individual state, they may not have a restriction at all. And if an individual state doesn't have a restriction on abortion, they don't have a restriction on abortion. So all Roe says is you can. That's what it says. And Casey says you can after viability, which generally would be something like 24 weeks. Now, the other way, and including in Florida, which we do have a restriction on abortion at 24 weeks, I'm pretty sure about that. The way they do this is by women's health, I'm telling you, because there's these caveats. That it's her mental health. That if she doesn't have this abortion, it's going to just wreck her life, and she'll never be the same. And so a woman's health is the gaping hole, and so they got to have something to tag it onto. Otherwise, states can have and can enforce rules against abortion under these two laws. Under these two holdings, two cases. There's nothing which says they cannot. Not all states do, and the ones that do almost always have an exception for women's life or health. You have a follow-up, don't you, Carolyn? Not now? Okay, fair enough. So anybody else? Yes, ma'am?
What about states like New York and I think Virginia that full-term abortions are allowed? How do they get away with it if Roe versus Wade is the law that we should have followed? Okay,
and thank you for asking the question, because I need to make this crystal clear. Roe v. Wade says you may have restrictions on abortion after 26 weeks. Planned Parenthood versus Casey says after viability. You may have, not required to. No. And incidentally, if Roe v. Wade is overturned, those will still work. Any state can have whatever they want if Roe v. Wade is overturned. And there may be a dip in some states. Surely there will be, but there'll be some other states where it continues unabated. That's how. Roe v. Wade does not make it. Listen, the fix is for probably a constitutional amendment which says life begins at conception. If there was a constitutional amendment that said life begins at conception, no matter who was on the Supreme Court, life begins at conception, and the unborn would have rights too. At some point, you have to say, I understand this woman's right to. I understand that, but bless their hearts, babies have rights too. Babies have rights too. And the issue, when does that begin? When does that? That's the issue. That is the issue. When does it begin? And the courts have taken the position saying, there's no consensus different than this, and that may be true. But of course, we think scripturally, life begins at conception. Most of us think that. All right. Any other questions about Roe?
You may want to answer this with the Dobbs versus Jackson, but my question is, so if they, quote, overturn Roe or Casey or whatever it is that we're concerned about, if they overturn this, what will happen if we haven't had the amendment? What do we expect to happen? People run to the streets, burn cars? What's
Sure.
What's next?
All those things will happen. But the fact of the matter is, it does not make, then it goes back to the states. It's like it was before Roe. Texas made a law. Texas can make another one. So can Florida. So can any state can make their own laws now. And the federal government cannot supersede. So the states make their own laws. And any state that has a genuinely, I hate to use the term liberal, but a broad interpretation which allows for abortion up to birth, some post-birth, but make an argument, still, that doesn't change. That does not change. Now the individual 50 entities will have control over abortion if Roe v. Wade is overturned. If Roe's overturned, Casey is as well, even though Casey really technically is the more recent case and did overturn some portions of Roe. Are we good?
Yeah, I think we're good. So this is why the governor, for example, of California might be saying, hey, they overturned this stuff, come to California, we'll get you your abortion, we'll take care of you.
It's exactly what he said. He says, as a matter of fact, we'll pay your way. We'll pay your way. So they can. They presumably they can. I mean, there's nothing which certainly says they can't. So they'll be. It's important, but it's not. It's not totally the answer. It's just not and there will be people that say. I already saying, of course, if Roe v. Wade is overturned, all these bad things are going to happen. And they probably will burn cars. But the fact of the matter is, it goes back to the states. It goes right back where it was before because of the 10th Amendment. Because of the 10th Amendment. That's not nothing. That's not nothing. And we may like it, we may not like it, but it happens to be one of the original 10. So there we have it. All right, Dobbs, this is the case now that's in front of the Supreme Court. It was argued on December the 1st. This is in our recent memory, many of us tracked those arguments. And recognize that it's not always possible to tell from the questions that are asked by the justices how they're going. It's not always possible to tell. As a matter of fact, let me just tell you this about which it's my view, but I have a plethora, an enormous amount of anecdotal evidence which says that when they have an argument like this, the Supreme Court justices don't come in there and say, you know what, I really can't wait to hear what these people have to say so I can make up my mind. No. They knew when they went in there. They knew when they went in there how they were going to vote. They really did. They really did. On something as big as this, those people can argue till the cows come home. And I'm telling you, they made up. Their minds are made up. They just are. It gives them some ammunition if they want to decide a particular way and somebody's made a particular cogent argument. But nobody's opinion was changed between November 30 and June, whenever this thing comes down. They all had decided. I'm just telling you they had. All right, but it was argued on the first. So this recent, and here's what it says: no abortion after 15 weeks. That's what it says. Except medical emergency or severe fetus abnormality. Among the most controversial tags is the last one, of course. But that's what this case says. Now, this was in 2018, I think this was passed in Mississippi. I want to say it was August or something. It was before the people who are in position of authority individually or in position of authority in Florida right now. But this is when this was passed, and the governor, Bredesen or whatever his name was, he said, I figure, when he signed it, he said, I figure there'll be a lawsuit in about 30 minutes. And he may have missed it by an hour or so, but he didn't miss it by much. And so this has wound its way through the courts, and it made it to the Supreme Court on December the 1st of this past year. And this case will be decided. This is the case that the Supreme Court is deciding right now, as what it says. It says no abortion after 15 weeks, none, except if there's a medical emergency. And it's not crystal clear what that means, but it's a little stronger than saying for the health or the mental health of the mother. It's a little stronger than that. So if there's a medical emergency or a severe fetus abnormality, no exception for rape or incest. That's the case. And that's what the Supreme Court is sitting on. And, my guess is that this will be upheld, which will effectively overturn Roe and Casey. My guess is it'll be 6-3, but it may be 5-4. But I guess I'm almost certain it'll be overturned. The thing that's not unimportant, and I emphasized this point. I emphasized this point when I talked about Plessy versus Ferguson and Brown versus Board of Education. That was overturned 9-0. In other words, there was a consensus. There will not be a consensus. Regardless of the vote, there will not be a consensus. There will not be anything like 9-0. Nothing like 9-0. Nothing like 8-1. Nothing like 7-2. I don't believe there might be a 6-3. I don't know, but I'm just going to tell you that's one of the reasons, preacher, that there'll be such turmoil is because it's still a hot item, and segregation by 1954 was not such a hot item, so that's why that was overturned without an enormous amount of. There still were issues, of course there were. Busing, for example, came up after that, so that didn't solve everything, but it was 9-0. This will not be 9-0, but expect this to be this Mississippi law to be upheld. I firmly believe it will be. Just in case. Just in case. So, the legislative session for 2022, the first opportunity after December the 1st, after the Supreme Court heard this, the first opportunity was 12 days ago, 2 weeks ago, this coming Tuesday. And the governor spoke, gave the State of the State speech at noon, and the session began, I believe, at 10 o'clock that morning. And at 10:36, while waiting on the governor, a bill was filed. Reducing Fetal and Infant Mortality, HB 5, and Senate Bill 146. So in the first few minutes of the session for this year, this bill was filed. Now, the bill was drafted by the leadership of the House. And at least currently, this bill, it looks very similar. It might even be identical, I'm not sure, in the Senate, but I'm tracking the House. You may know this or you may not know this, but Florida, in most states, Nebraska being an exception, but most states, it's bicameral. There are two houses in the legislature, not unlike the federal government. There is a House, like there is the House of Representatives in Washington. There's a Florida House. And there's a Florida Senate, like there is a United States Senate. And so, these people, they function similarly. They have, they introduce bills and they have committee hearings and so forth. And this bill, the first reading was that first morning, again within a few hours of when the session came together. And it went immediately to committee, and it has now survived. It was a subcommittee, and 3 days ago it went out of the subcommittee, might be 4 days now, it's Sunday. Came out of the subcommittee on a party line vote, without mentioning parties, 12-6. So it came out of committee and is now moved along the line. Assuming this bill gets through the House, and it will, and assuming it gets through the Senate, and it will be signed by the governor. And it will take effect on July the 1st, 2022. Here's what this bill says. No abortion after 15 weeks, except if two doctors agree that the mother's life is at risk. In other words, if two doctors agree that if we don't abort, the mama's going to die, then an abortion would be an option. So that's the way that Florida has handled that. And the second one is, if two doctors agree that the fetus has a fatal fetal abnormality, that's different than saying they have a severe abnormality. That's different, isn't it? If two doctors agree that the baby's going to die, then it's okay to take the baby. It's okay to take the baby. Those are the two restrictions on the Florida House Bill 5. No exception for rape or incest. And you know what? That already, of course, is getting the same kind of attention that it's gotten other times that that's come up. That everybody wants, not everybody, whoa. Politically, it's much more palatable if there's an exception for rape or incest. And you know what? I understand that. I get it. You know, I have a position on that, and you're allowed to disagree, and we'll give you a moment to disagree if you choose. But my position on that is rape and incest are crimes. And so if a rape was committed or incest was committed, a crime was committed, and I'm totally on board with punishing the perpetrator of the crime. But the baby did not commit the crime. The baby did not commit the crime. That's the wrong one to punish, my view. I totally, absolutely agree with this. And I understand that people say they have different view. If it hits you personally, I don't know. I hope I have the courage of my conviction and to say the baby's not at fault. The baby's not at fault, and why the baby should suffer a capital crime for a crime somebody else committed is beyond me. It's beyond me totally. So I'm totally on board with this. You know, I hesitate to mention what I'm about to mention, but my wife has given me special permission, and you'll be happy to know that I always. The Speaker of the House, and if you think about this for just a moment, I really don't want to focus on this too much, but I think generally everybody knows the Speaker of the House in Washington. And the Speaker of the House has enormous power because she, in Washington, of course, controls what bills are decided and what assignments are made and who sits on committees and how things pass through and when votes, if at all, are taken. The Speaker of the House in Florida is a guy named Chris Sprouse. And Chris was a student of mine at Stetson for 3 years. You know, there may be people in the state of Florida more determined to protect unborn life than Chris Sprouse, but there's not many. There's not many. He is a rock star. He's Catholic. He is a rock star on this subject. And Chris will not allow anything to go wrong with that bill in the Florida House. And if anything else is needed, he's there. And you know, my personal view is that someday, if he chooses, he'll move up because he's really, really a special kind of a guy, smart as anything, and his character is unimpeachable. Unimpeachable, in my view. Sprouse is his name, Chris Sprouse. All right. And there you have it. That's the status of these bills, and that's where they are. And we're right up against the time. Fact is, we're out of time. So unless there's some reason to go further, I think we will have covered the subjects nicely, and we may even allow you to a little time next week, even as painful as that is.
Checks in the mail.
Checks in the mail. I'm happy for us. Right.
Moment for questions.
I'm happy for a moment for questions.
Just for you. These are those things that you handed out, and I made extra copies, and all the ladies at the ladies' prayer luncheon signed it. Do you want me to leave these or check with anybody that didn't get one? Or
Okay, here's the history on that. A week ago, 2 weeks ago, strike that, Travis I think, gave the preacher an envelope, which I have some with me now, and it had like 30 petitions. And I think he said to the preacher, "What do you think?" And the preacher said, "I'll give them to my dad, see what he thinks." So I mentioned it last week, and a bunch of people came and got them. I was not endorsing that, although I'm signing it myself, as is my wife. So the answer is, I don't have an answer, except you have additional copies. There's additional petitions. This is the heartbeat, isn't it? It's the 6 weeks to heartbeat.
The Human Life Protection Amendment. All human beings have a right to life regardless of age, illness, or disability, where there is a detectable heartbeat.
Okay, so it is the heartbeat. So it's generally after 6 weeks is when this would take effect. There's a different thing in Texas. I don't want to confuse that Texas thing. It's not like any of these other bills. The one that's been passed in Texas and generally has survived to this point. But the answer is there's an amendment. So this would be a Florida amendment. And so so what would happen is Florida's Constitution would say then when the heart begins to beat, then that person is entitled to protection. It's not the same as conception, but it's better than 15 weeks by several. So anybody who chooses to, there's an address on there that they can be sent. But that again, that's
Or if they fill them out, I'll send them all in for them.
fair enough. Fair enough. Linda's taking the bull by the horns or something. Yeah.
Got it.
Any other questions? Are we good, preacher?
Thank you. Thank you. Hey, close this in prayer, would you please?
Sure enough. Father, we thank you so very much for the occasions that we have to consider important things that we as believers, of which we need to be aware, Lord, and we should be the salt and the light, and that, Lord, we can best be that if we are informed. And we just pray, Lord, that you'll give us wisdom, and we'll know how to pray, and we'll know how to vote, or we'll know how to have conversations or discussions with people about things that are really, really important that affect believers. And Lord, if there comes an occasion when it's important for us to obey God rather than men, then Lord, give us the courage to do that very thing. We'll be careful to give you the praise in Jesus' name. Amen.